So, hello everyone, I'm Christina, and I would like to thank you all for choosing to attend this presentation. Its level is for beginners, so I will not speak about anything that is complex about the law or about the artificial intelligence world. First of all, I would like to ask you all, how many of you have heard about the GDPR? Okay. And second of all, how many of you can surely state that the company you are working for is indeed GDPR compliant? Well, one fact about the GDPR is that nobody can truly say that they really comply with it. And this is like, to make an analogy, like stating, for example, that like stating that we comply with the criminal code. One cannot say that or obtain a prior certification that we comply with the criminal code. This is something to be decided by a certain authority in a particular situation. So I'll start with a comparison between the human mind and the artificial intelligence mind. In one of his books, Cicero was telling us the story of Themistocles, who made an interesting choice back in the antiquity. Instead of learning to master the art of remembering, he chose to master the art of forgetting, the ars oblivionalis. And this was because of two reasons. The first one being the fact that he was unable to expressly forget something that was in his mind. And second of all, because everything that he ever saw and heard was just unable to get out of his mind. And as important as it was to master the ars oblivionalis, it turns out that there's a paradox. And the paradox is the fact that we cannot remember to forget something. To make a demonstration, if I tell you, for example, please don't think about the GDPR, you, at this moment, will think about the GDPR. So Umberto Eco stated, because of this reason, the fact that there is no such thing as an art of forgetting, as an art of oblivionalis. Now, in the research world, cognitive psychologists are talking about two systems of memory, the long-term memory and the short-term memory. Even though they sort of agree with lots of things about these two, they don't agree on two aspects. The first one is related to how much can the human mind store, and the second one is why exactly are we offering meaning to certain things and we remember them, yet we so easily forget other stuff. Okay, on the other hand, the so-called AI mind is not really reasoning on the same logic as humans. However, what is important to notice is the fact that humans are the one always in control with the machine. So ultimately, it matters how humans are forgetting, not how the system is forgetting. Now, regarding the AI, we can state for certain that AI systems are definitely remembering better than we are. And about forgetting, we can say that AI, we understand generically about the AI three main aspects. We have the data input, which is clearly defined at the beginning, yet it lacks meaning for the machine. We have the storage of the memory, which is a progress compared to humans. And also we have the deletion aspect, which does not face the forgetting paradox I was telling you about. Now, let's see what is AI. I categorized artificial intelligence in this matter. First, we have the notion of reinforcement learning, and this is more generic AI. It's related to robotics, to gaming, and it's related basically to the behavior that we are expected to have. And if they manage to guess it, then it gets a cookie. Secondly, we have here the notion of neural networks and deep learning that has as model what we can see in this image. And in this image, we can notice an input layer at the beginning, a hidden layer, and in this case, we see a multiple layers where we can find different variables, and an output that can be something looking like an input, for example, in the situation of a dictionary, or something totally different from another class. And the backpropagation algorithm has practically as basis the same logic as the notion of reinforcement learning, the system of upvotes and downvotes. And over time, basically, if the information gets right, the system gets reinforced. If it's wrong, then it gets corrected. That means that over time, the system becomes more powerful by this trial and error mechanism. Now, even though the research world does not really agree on lots of stuff regarding what's going on in the hidden layer, in the so-called black box of the neural network, what we do understand by the system of trial and error is the fact that the quality of the data is fundamental, and this raises a direct question of what is happening if we choose to delete something from inside the neural network. But what is the right to be forgotten? Because this is the reason why we choose to delete something. Practically, it's the right of the individual to obtain, automatically or by request, the deletion of personal information that is no longer relevant or useful, and which was posted online by either the data owner himself or by a third party, and even if initially it was legally posted. And I would like to sustain in this presentation the fact that in the name that the right to be forgotten ultimately is related to the way humans are forgetting and not the way machines are. Now, let's see which are the relevant texts regarding the notion of the right to be forgotten. We have first here the directive from 1995, which was invoked in the second decision on the decision of the European Court of Justice regarding Google Spain and Google Incorporated versus Mr. Gonzales. And also we have Article 17, which became Article 17 from the GDPR, which became a reality in May, entitled suggestively the right to be forgotten. Now, what happened in this case and why is it so important for us? Mr. Gonzalez, back in 1998, noticed that every time he was entering on Google and was Googling his name, a certain notice from something way in the past was appearing. It was about him not being able to pay a certain debit in the past, and basically he decided at that point to list his house for auction in the La Vanguardia newspaper. And at some point after like 10 years or so, he decided that that information is not relevant to be attached to his name. So he decided to go to the newspaper and say, oh, please, newspaper, delete me. But the newspaper's answer, the La Vanguardia's one, was the fact that the information initially was legally posted, so there's no reason why to delete it. So the information remained there. Then he went to the Spanish CNIL, which is the AAPD, and the answer of the AAPD was the same. And confronted with this situation, he decided to go to the Spanish court, the Spanish National Court. And the Spanish National Court decided at that point to ask the European Court of Justice 3 preliminary questions. And the answers were the following. Regarding the first one, the European Court of Justice decided that the directive from 95 applies directly to Google Incorporated in the US and not to Google Spain. To the second one, the European Court of Justice said that the search engine qualifies as a data controller, which means more regulations than the situation in which it would have been a data processor. And the answer to the third question became the definition of the right to be forgotten that was replaced on May 25th with the Article 17 from the GDPR. Now, let's talk about some statistics regarding companies and the GDPR. This is a study conducted on 750 IT companies from US, UK, France, and Spain. And to the question, is your company, if your company receives a request based on the right to be forgotten, what is the method that you would use to delete the content? They answered that basic deletion as one of the most preferred methods. This meaning that for example, this meaning practically dragging files from the desktop and moving them to the recycle bin. And this does not provide a physical proof of erasure, for example, in a situation of an audit. And by the way, this does not apply to AI systems. Now, this is a list of number of requests that were made to Google after the ruling of Google versus Gonzalez case at the European Court of Justice. And the source is a transparency report that Google published after organizing to comply with the decision that was taken in the Gonzalez case. Practically, Google's response was to hire dozens of lawyers and organize an advisory council in 2014 in order to analyze requests and determine whether they should be accepted or not. At the national level, what is interesting is that here in France, the CNIL was the first authority, national authority, to ask Google to extend its removals globally in June 2015. Now, Here we can see some criteria for evaluating requests received by Google. And neither of them is determinant per se, and there is also no hierarchical order between them. The first one is the role of the subject in the public life. So basically, if we speak about a public person, that information might be relevant for the public. Then we have the nature of the information, and this can balance more on the side of protecting privacy, or can balance more on the side of the public interest. For example, in a situation of a crime, it's important for us to know. Then we have the source of the information, which refers to the motivation of publishing. So, for example, if the information was initially posted in a very important paper, it's difficult to get it down from there. And time is also a factor. And this is, for example, very relevant in criminal cases, because after a certain time, if we committed something that's not like a small crime, it's not so relevant to read about it after 20 years, for example, because that stuff sort of gets attached to our name and is not okay. It affects our reputation. Now, what happened, however, with the requests that Google accepted? Now, if we make a quick search on Google, we can actually find on different sources information about those requests. And this happened, for example, in the case of Gonzales, of Mr. Gonzalez, who initially wanted more privacy, but at the end it ended up being everywhere because he became famous. Even in this presentation, I'm speaking about him. And the thing is, reputational management sites weren't the fact of a boomerang effect, because if we draw attention to a certain information, we actually make everybody more curious to find out information about it. And this is something that might happen in the case when we ask in the name of the GDPR to delete something. Even more, when a request used to be deleted by Google, in the place where the information was initially listed, we could see a notice saying that this information was delisted in the name of the right to be forgotten. And also there are some there are some sites that collect the links removed, and also Wikipedia at some point collected links that were removed from Google. And so basically it's not really forgetting. No, thank you. Now, here we can see what is happening when the data gets removed from the search index. This is for MySQL, but applies to all the most relevant databases currently existed. In Figure 1, we can see the database before deletion, and we have 5 records sitting in spaces C1 and C5, and the start, which is I, and the end, which is S. And then on record C3, we can see that it is linked to the garbage offset, which is a collection of deleted records, and it's currently available for free space. And when the database practically is searching for the data, starts at node I and follows the path of the arrows until the search data is found. And if the search arrives at node S with no result, then the data is not found. And as a conclusion, this is not really a complete deletion of the information, because the information still remains there. And it will be deleted when the space will be needed to be available for other information to appear there. And this raises a direct question of what is exactly deletion in the spirit of the right to be forgotten. Is it practically a simple removal from the search index, or is overwriting in the file system, or we want it removed from all internal mechanisms? Now, the answer to this question is very important, because each one of these methods in reality have a different economic value, and it's quite problematic. And this is a realistic quote from Vivian Reading, the European Commission Vice President at the time of the Google versus Gonzales case at the European Court of Justice. Now here, you can see the major investors currently in the AI technology, and a glimpse of the amount of the information that they are taking from us. Currently, we can speak about another paradox. We sort of are confronted with a situation of having to have different, we are confronted with a situation of needing a LinkedIn account, a Facebook account, a Twitter account, and so on, but yet we are so focusing on protecting our privacy at the same time. And people, sometimes not informed, voluntarily give away their data, and they are not so informed about the risks that are implied. For example, who used to read privacy notices before the GDPR. Now, hopefully the GDPR will manage to raise awareness about the risks of sharing our data. Now, how is exactly this huge amount of personal data used by these companies? They are, first of all, capitalizing it, which is not such a big secret. And second of all, they are using it in order to improve their AI research to deliver better in production. Of course, the progress of science is not so bad per se, but the problem is we need to consent to be a part of that. Now here we can see a status of the AI systems and their performance. And this is an image from a research. The significant part about the research world in general is confidential, so this is something which is public. These are some examples that I could have found publicly. And we can see here that in the first image, the AI classifies it as a panda with 60% confidence. And if we apply a tiny adversarial perturbation, the effect after this is that the AI classified it as a gibbon with 99% confidence. And this is another example. This is actually Apple's most advanced Face ID technology, and it was branded as being able to detect if someone is hacking into your phone with a probability of 1 in 1 million. And in this situation, it couldn't have tell the difference between these two co-workers. Now, how do we control forgetting on the web in a way specific to algorithmic memory? We have a tactic called obfuscation, which dates back in the Second World War, and it was designed to produce misleading, false, or ambiguous information parallel to the relevant one. Practically, we sort of multiply the information available, and by multiplying it, we sort of draw attention to we are bombarded with different information. We are hiding the relevant information next to other types of information, and people are confused when they are searching it. But this technique, however, even though is great in general, does not work for AI systems, because in the situation of AI, we need, and in the situation of a deletion request, we need to forget something that initially we never have thought it is necessary to forget. So it's problematic to apply this tactic to such cases. Now, let's see what happens if we try to delete something from an AI system. One research study conducted in this field reached the conclusion that if we delete one element from inside AI, it does not have a large-scale effect on the quality of the machine. Though this research was conducted was not conducted in a situation when we actually delete something in particular. They practically just deleted randomly a certain piece of information. Now, another research is related to making the data less sensitive, which would mean that it will not be so relevant for the GDPR legislation, for the data protection legislation. And however, in this situation, if we make the data less sensitive, the GDPR, for example, states that we, however, need consent from the people. And another solution might be functional encryption algorithms, which does not work on big data. We have pseudonymization and data anonymization, which are like other two aspects that were proven not to be working in this case. And here we can see some possible approaches to respect the right to be forgotten in the AI environment. And the first and most effective one is data minimization, which is quite interesting because this means that governments and companies should not collect information, that the information that is not needed for performing a certain action, which was consensually accepted by the data subject. Then we can have an interdisciplinary research, which is dedicated specifically to applying deletion requests in AI systems. And also future laws should address this problematic because the GDPR does not talk specifically about the AI, so we don't know exactly how we should apply it legally. And regarding the GDPR in general, we can use it, because it is our opportunity as Europeans to make it a state-of-the-art for other continents and for other countries that do not benefit from it, in order to protect our privacy. So in order to claim respecting our privacy. And also we can start using secure alternatives to mainstream products. And I selected here a few that I personally used. We can see here Mastodon, which is a decentralized social network. We can see Matrix, which is an encrypted end-to-end chat. And we also see CryptPad, which is a zero-knowledge collaborative editor. And these are my contact details. Feel free to contact me and discuss further about this topic. And if you have any questions, I'm available to answer them. Thank you.